stop, para, from the set of copies letters, set of office letters, comma, it is noticed that the same are correspondences between the District Legal Services Authority, Morigaon, to the District Magistrate, Morigaon, and to the Inspector General of Prisons, Guwahati, Assam. Full stop. Para, from the letter from an office letter number so and so dated 9/12/2024, comma, the Secretary District, it is noticed that the Secretary District Legal Services Authority, Morigaon, wrote to the District Magistrate, Morigaon, Assam, to extend financial benefit to the petitioner pursuant to the resolution taken by the empowered committee in its meeting held on 22/11/2024. Full stop. A copy of the minutes of the resolutions taken by the empowered committee on 22/11/2024 is also placed on record. Full stop. As per resolution number 4, the empowered committee on 22/11/2024 unanimously resolved to provide financial benefit to the petitioner. Full stop. More than 9 months, about 9 months have elapsed since 22/11/2024. Full stop. Yet, the petitioner is in incarceration. Since, incarceration, full stop. Para, Mr. Pegu and so has paid for a week's time to obtain definite instruction as regards the provision made for providing the security for release of the petitioner. Full stop. Place the case on. Week's time, Tuesday. The name of Mr. G. Pegu, learned junior government advocate, is to be reflected in the cause list. A copy of this order is to be furnished to Mr. Pegu and his friends for taking necessary steps from his end. Yes. Yes, Mr. Roy Chaudhary. Next week, yes. Next week.
Company was represented by somebody who expired, and I have filed an application for substituting a person because the conviction remains with the company.
What is your prayer in the IA?
For substituting the company representation.
P.K. Roy Chaudhary for the applicant. Furnish a copy of it to Sharma. Now, what is the application? Order 1. CPC is not applicable in CRPC.
They have written it wrongly. It's there.
We cannot go to that extent to apply the principle of CPC in CRPC.
I understand. That is wrong, man.
Sorry.
But the only thing is this, Malad, that he has to be, the company has to be.
You don't see or you don't vet the application.
Malad, because this was not available to me, it was with somebody else. Then I got a copy, Malad. Because in that conviction remains with the company, Malad. Previously, Kishan.
Yes, Mr. Sharma.
This time, my lord, I have to obtain a signature. Well, my colleague has obtained a signature. Last time also the prayer was.
But this is not my signature. Somebody receive on behalf of mine.
Lekhak hired Mr. P.K. Roychuri, learned counsel for the applicant appellant, and Mr. B. Sharma, learned additional public prosecutor for the respondent state. Food adulteration, perhaps.
My lord,
Food adulteration.
my lord, idea it was Kishan Lal Sharma, now it will be
No,
Anand Manohar.
conviction is food adulteration.
My lord, I have understood.
Prevention of food adulteration.
Good word. Prevention of food error.
So, from the applicant as a revision petitioner. The applicant is a private limited corporate company.
My lord,
Huh?
my lord.
Full stop. The applicant as the appellant has preferred, as the petitioner, revision petitioner, has preferred the accompanying criminal revision petition, criminal revision petition number 330 of 2012 under section 397 read with section 401 of the Code of Criminal Procedure 1973. First up, in the revision petition, a judgment and order dated 2/9/2011 passed by the Court of Learned Chief Judicial Magistrate Nagaon in CR case number 2079/2007 has been assailed. By the said judgment and order dated 2/9/2011, the revision petitioner has been convicted under section 16(1) small a small Roman 1 and small Roman 2 read with section 2 small Roman within bracket small Roman IA bracket close within bracket 1 and section 7 within bracket 1 of the Prevention of Food Adulteration Act 1954, and the petitioner has been sentenced to pay a fine of rupees 5,000.
5 lakhs.
5 lakh. Full stop. When the said judgment and order dated 2/9/2011 was challenged by carrying the matter in an appeal before the Court of Learned Additional Session Judge Nagaon in criminal appeal number 34 within bracket N of 2011, the appellate court dismissed the criminal appeal by judgment and order dated 1/6/2012. Full stop. Thereafter, the accompanying criminal revision petition has been preferred. Full stop. Para. It is ever that during pendency of the criminal revision petition, the representative of the petitioner company, namely Kishan Lal Sharma, had expired, and therefore, full stop, as a result, necessity has arisen to implead the representative of the petitioner company, and hence the instant interlocutory application. Full stop. Para. The instant interlocutory application is preferred seeking impleadment of Sri Anand Manpuria, son of Ram Gopal Manpuria, resident of so-and-so, as the authorized representative of the petitioner, revision petitioner company. Full stop. Para. Having regard to the facts projected in the instant application, as narrated above, the instant application seeking impleadment of the aforestated applicant as the authorized representative of the petitioner company, Messrs. Rosoi Limited, is allowed. Full stop. The applicant is to file an amended cause title in terms of the notification dated so-and-so before the registry of this court within 3 weeks from today, 3 days from today, post on receipt of the amended cause title, and the registry to do the needful.
Always.
Yes. Read it. Yes, query.
Item 40.
Matlab here, matlab I have for suspension of sentence and bail. At this stage, notice may be issued to the court.
Heard Mr. B. Burwal and counsel for the applicant appellant and Mr. B. Sharma and additional public prosecutor for the opposite party number 1, State of Assam. The instant application is preferred seeking suspension of the execution of sentence passed against the applicant appellant and for his release on bail. Post of the conviction is under section
4 of POSCO Act.
4, protection of children, so and so. Issue notice returnable in 4 weeks. As Mr. Sharma has appeared accepted notice on behalf of the opposite party number 1, State of Assam. Formal notice dispensed with. Where is the police station?
Matlab Udalguri.
Practice direction. Respond opposite party number 2, that's informant. Practice direction. And where is the judgment?
Matlab page 31, matlab.
Police station, Masbat
Masbat is.
Police Station, officer in charge. Additional public prosecutor.
Obliged.
41.
Register for the practice direction. POXO no?
May it please your lordship, this is appeal against conviction under section 10 of POXO and 440.
Item number 41.
Yes.
Yes.
Actually,
How many days?
delay of 44 days.
Yes. Heard, Mr. A. Trail and counsel for the applicant appellant and Mr. B. Sharma. Opposite party number 1, State of Assam. That's what 44 at this stage not required. Because at the time of hearing of appeal, informant number 2 is to be heard. How many, what is the term of imprisonment?
5 years, lordship,
Okay.
under section 10.
Division bench. Yes.
42.
Obliged.
In this case, delay is of 30 days, although the case was under POXO, but POXO was the proved
Conviction, it's
conviction under by lot 448 and 354A2.
30 days.
30
Yes.
days.
Well,
The T. Chakraborty. 30 days. Conviction,
Conviction, convicted
Look,
6 months of simple imprisonment under section 448 and rigorous imprisonments of 2 years and 6 months for the offense under 354A2.
division. Yes.
Kundum.
Item, this is 882.
882,
882. 30 days, 40 days.
Well,
I'm deeply obliged. I'm obliged.
Hmm. Yes.
Lordship, correction of the address mentioned as a board.
Order was passed on 5/4 and the rectification of deed was done on 18/7, lordships. So what is the wrong in the that affidavit, that order, lordship?
Lordship.
After the judgment, lordships, the deed has been rectified.
Oh. Deed has been rectified thereafter. So whatever, there is no fault on the part of the court.
Lordships, it is not fall on the part.
Lordship, I am
How
also
can
not,
we correct? We correct our orders.
Lordship. I am also not fault of the order.
Then
They have to approach again.
file a fresh one.
Lordship, which has been made by the agreement, he was for Lordship, earlier read petition.
So how can we now future event we can
Even then,
incorporate?
that typographical error or other things.
It cannot be typographical error.
It is not a typographical error, lordships.
Order passed, thereafter you have corrected. Had it been a case that earlier there was an agreement,
Lordship.
you have typed it wrongly. We can do so, but here is a case, this is subsequent.
Subsequent, lordship.
I thought that on the last day you were there, no?
Yes, Lord.
So I thought that we can allow, but now it is a fact pointed out.
Lordship, I have annexed there with Lordship, new agreement, Lordship. Rectification agreement.
File in the press, lordships.
It's difficult now.
Already Lordship process is going only due to mistake of the village name, Lordship.
No, subsequent agreement these are. Your right flows from that agreement, right?
Lordship.
Rectification deed is page 21.
Paragraph
22
two of the
Lordship.
order, two of the order.
Order Lordship,
Please,
page
please,
10
please,
Lordship.
page 10. It is recorded after executing a notarized agreement dated 10/3/2023. It will be difficult.
On the basis of that, Lordship date, Lordship was passed in disorder, Lordship. Now, my Lord, after the judgment, Lordship, he has been rectified. Lord, how can Lordship and modification of this?
These are 18/7/2025. How can it be? Because entire order is based on this 10/3/2023.
2020.
Lordship.
BS Mr. Borpatro Dole Kalugao.
Yes, Lordship. It should be Joysagar, Lordship now.
Only that, only that.
Yes, Lordship.
Only that. Lordship.
We'll say that we'll not refer to this agreement.
Lordship. Lordship. That,
Heard Mr. P.K. Google, learned counsel for the petitioner, Mr. J. Hendrick, learned state counsel for the
Lordship, all the respondents, my Lord, that.
all the
revenue
respondents for all the opposite parties. Full stop. The instant application is preferred. Seeking correction in an order. Seeking correction in a judgment and order dated 8/4/2025 passed in a writ petition WPC number 1466/2025. Full stop. In the
দুটা আছে।
in the writ petition, comma, the applicants as the petitioners had projected that they preferred an application how many single okay applicant huh? He preferred an application for a notified public service, comma, quote, conversion of land from annual patta within bracket AP to periodic patta within bracket PP, unquote, in compliance of the provisions, no, like a full stop. In respect of a plot of land described therein. Full stop. The full stop. In the judgment and order, comma, sorry, the applicant has stated that an error had crept in paragraph 2 of the judgment and order dated 5/4/2025. In that, the applicant in the writ petition had mentioned the that the plot of land located at village Borpatro Dole Kalugao instead of village Joyhagar Gaon. Full stop. The relevant parts of paragraph 2 of the judgment and order dated so and so read as under paragraph 2 Dagor pa Dag. Where the applicant has stated that the mistake is clearly attributable to him and the vendors and the other party in the notarized agreement dated 10/3/2023. Full stop. The applicant and the other party in a notarized agreement dated 10/3/2023 had executed a subsequent notarized agreement on 18/7/2025, rectifying the name of the village as Joysagar. Full stop. Mr. Hendrik Lanet, the Land Council for the petition applicant has further submitted that as the matter is being processed, the applicant will suffer immense prejudice if the application is not allowed. So Mr. Hendrik Lanet, State Council has fairly submitted that the opposite parties have no objection if the prayer regarding correction in the name of the village is allowed. Full stop. Para having heard the Learned Council for the parties and considering the nature of correction sought, it is observed that the relevant parts of paragraph 2 of the judgment and order dated 5/4/2025 should be ought to have been read as under. বুলি কৈ খালি এই বৰপাত্ৰ দলে কলু গাঁও নামটোৰ ঠাইত জয়সাগৰ গাঁও লিখি দিলে হ'ল। This order is to be treated as part and parcel of the judgment and order dated 5/4/2025. The application stands accordingly disposed of.
Highly obliged. Second is also same lot,
Same
same lot,
notarized agreement,
Same date.
same lot,
same date. The village is same.
same lot.
School.